Jennifer, I can't hear you.
Okay, I think we're all set. Can you hear me?
Okay, I'm going to let you go. I'm got to figure out what's going on with my computer. Okay, welcome everyone. This is Laura Peterson from RERM. Today I have the pleasure of announcing Jennifer Sawday, who is going to be talking to you about trust wills and probate, and the services that are available through RERM. So I'm having a few technical difficulties, so I'm going to let Jennifer take it from here. Jennifer, thank you very much for providing this webinar this afternoon.
Well, thank you. I'm gonna share my screen. We're gonna go through some charts. If you have questions, just put them in the chat box, and we'll do our best to grab them and answer as we go. But let's get the sharing going. Okay, so I'm putting on a slideshow, and I'm over here in Long Beach, California. I'm actually in my office, so you can see the traffic going by. I'm right by the airport, so I'm on Spring and Lakewood. I'm one of the probate and trust attorneys for real estate risk management, so we offer free consultations and help agents, buyers, and sellers with their needs. But let's kind of jump in and talk right now about probate. So we don't want to go through probate. We want all of you to set up a trust, right? So if you look at this chart, we have four documents. We want every homeowner or every individual to have a trust, part of a will, power of attorney, and a healthcare directive. These are four documents. At a minimum, everyone should have easy. The trust is the document where we put everything in it, and if it's in it, it avoids probate, meaning when the person passes away, the successor trustee takes the asset, opens it, reads what to do, and can install themselves to be the successor trustee and do what's next. Sell the property, convey the property, grab bank accounts, to do all that. We'll talk a little bit about trust administration, but first we want to set up the trust. And then we also set up what we call a pour over will. The will is two things. We nominate guardians for minor children in there. So if you have a young family and something bad happens to mom and dad, they get to write who has custody of the kids. And then the will that we prepare is also called a pour over will. Something did not make its way into the trust. The pour over will takes it, whatever it is, and pours it back into the trust. It connects it. But if I have to use the pour over will, I'm going to probate court for that asset to put it back in. So that's two out of four documents. The other two documents that we'd like people to have is the durable power of attorney and then the advanced healthcare directive. The durable power of attorney says if you're alive but not well and you become incapacitated during your lifetime, who should make financial decisions? This is a nice document to have. If you have a well-drafted power of attorney, but you don't have a trust, using the power of attorney, you may be able to sell property for someone. So it's nice to have it just in case. And then the healthcare directive is a little bit more self-explanatory. You're in the hospital, you're not able to make medical decisions, who should come in and be your helper? So when we have clients that are buying and selling properties, or for yourselves or your families, we want everyone to have all four of these documents. We want you to have them all together. We want you to punch holes in them and put them in a binder with tabs, trust, will, power of attorney, healthcare directive, and put them in. So if something happens and a first responder comes into your property, they know what the binder looks like. They grab it, they open it, and they start making phone calls. So it's nice to have it. We don't want to hide these documents. We don't want to put them in an envelope. We don't want to put them in the bed, in the bedroom, under the bed. We want them out visible. Bookshelf in the den is a great place for it. And you want to open them up, punch holes, and read them and have them readily available. And you put other things in the binder as well. If you have strong feelings about funeral instructions, being cremated, your safe deposit box information, you can put all of that stuff in the binder. This is the minimum of what estate planning is. This works well for most of us here in California. You have anywhere between $50 to 5 million, you need a trust, right? So this is what it is. Estate planning, four things. Okay. So when we talk about setting up the estate plan, it's nice to do it when you can argue with me, right? You could drive to the office, you can get ornery, you can push back, and we can argue over how the trust is drafted. It means you're alive and well. We're not rushing. Good fees, it's well done. If you're not well and we have to do a deathbed signing or go to the hospital, everyone is uncomfortable and the rush fees get high. And if you've passed away, it's too late. There's nothing I can do in my toolbox when someone passes away, very limited. We'll talk about that in a little bit. So one of the things that we want to talk about is the alternative is if you don't have a trust and you own property here. Let's say you have a nice home in Long Beach. It's worth $1 million and all the property owners that were untitled have died. Mom died, then dad died. So we have dead owners untitled. So say it was owned by Jennifer and Donald Sawday. Husband and wife is joint tenants and we're gone. That property is going to go through probate. If that home was owned, which what my home is, Donald and Jennifer Sawday, trustees of the Sawday Family Trust, dated June 14th, 2004. If I pull title and it's in my trust, that means my trustee can sell that property for me during my lifetime if I'm no longer trustee and I'm incapacitated, or at my death to distribute that property to my next of kin based on the trust. So when it's in the trust, that means we can settle that property here in a conference room and not in a courtroom. If the property is not in a trust, then we have to go through probate. Now, surviving spouses can do a spousal property petition in some cases, so it's a short version of probate. California law does have another petition to avoid probate if it was the primary residence of the person who passed away and the value of the home at the date of death is less than $750,000. So that does not work for most properties anywhere in LA or in Orange County. Most homes are worth more than $750,000. If we do have a condo or something smaller or it's more rural or remote, then maybe we can use that new petition. When we meet with the family to decide what we do, the courts want us to give you the option of what's the least expensive and the best in that situation. So we will go over all the available options. We'll talk about a Hegstad too as another option. If we open probate, we do the primary residence petition. If we have a surviving spouse, maybe we do that. Or if it's a probate, in terms of where the property is not in the trust, but we think it should have been in, we can avoid probate and do what we call a Hegstad. So we can talk about these different things. But I have here what the fees are. These numbers have not changed. So the probate is based on the value of the property. So it's $1 million property. If that's what the court values at, the fees to open that probate and get it going and to sell it at the end, the payment to the executor and the attorney is going to be $46,000. The attorney gets half and the executor gets half. Those are what we call commission to the attorney. It's fixed by the court. And so you're not shopping on price. You're going to be shopping on who can handle this the best for you. So these are probate fees. Now, probate also has expenses or costs where you pay the window, the filing fee to open probate, the filing fee to close the probate, to run the legal notice, to pay for bond, to get the house appraised. So we have all these different costs that you're paying as you go for these different vendors. So costs right now have gone up. It's on average about $4,000 per probate. This is a little bit low when I did this a couple years ago. And so when you look at the fees in this chart, for every $100,000, the attorney gets a percentage. And then we have filing fees and costs. So we ask the family to pay this money. When you set up an estate plan, it's not $2,800 for a single person, right? So setting up an estate plan is just saving the family a lot of money by not having to go through the probate process. So all of that's kind of in there. So we want to avoid this. This chart is designed to make you angry. Because I don't pay the filing fee to get into court. I ask your family to pay. They have to pay the $500. So it gets expensive. So most probates are money makers for the firm. It's paralegal driven. We do all the hearings remote. We, before the pandemic, had one probate paralegal that handled all of the phone cases. Now we have six probate paralegals. Each girl has about 60 cases. So you can see that the probate sphere has gotten a lot larger, and people are just not doing the estate planning like they should be. So when I have clients in front of me, my job is to tell you or recommend what's best for you. If we want to avoid probate, we want you to have these documents. So these are all these different things that we talk about. One question that comes up when we talk about estate planning is, do we have a taxable estate? The answer is probably not. The government takes an estate tax if your estate is larger or a growth at 15 million per person. So for a married couple, that's a $30 million exemption. California does not have a death tax right now, so that's nice. But when we talk about setting up that trust and putting everything in it, this chart here kind of shows you what should be in it, right? We want your home to be in it. We want your rental property, commercial properties. I want your corporations, your LLCs, your partnership, oil, gas, mineral rights. I want everything to get it connected to the trust. And if it's not going to get connected to the trust, then I want it to have beneficiary. So I have this chart here that talks about account investing options. So let's say you have an account at Schwab and it has $500,000 in it, and it's a brokerage account. That account ideally should fall under number one. The trust should become the owner of that account, as Schwab, so that when we get the bank statement and it says Sawday Family Trust on top. Some banks don't like trust as well as others. Chase Bank comes to mind. They're not very trust friendly. So at Chase, we may not get the account named in the trust, but you can update the payable and death beneficiary at Chase to be the name of the trust. So the bank statements, when they come to you every quarter or every month, can still say it's owned by Jennifer. But when I go online on the computer and it says 100% payable to the Sawday Family Trust if I were to pass. So that means it's coming in. And then some families prefer to name individuals. So if you have a favorite niece or a nephew and you have a little account set aside and you wanted to go to that person, you may name him or her to be the beneficiary. And that's fine. You could do that. The trust could be the backup after, because you could do primary and then secondary. Most clients do a blend of things. Some things are in the trust, some things name the beneficiary of the trust, and some things name individuals. So this is where the estate planning comes in. When you sit with me, you tell me, is it all going to charity? Do you have adult children? Do you have minor children? And we give you customized instructions on how things should be vested and how it should go into your trust. So that's kind of my estate planning presentation in a nutshell, right? So now what I want to do is I want to talk about what you want to talk about. So when I gave this presentation a couple of weeks ago, Laura gave me a list of what if questions that were asked by the agent. So I want you to look at these questions and I'll go through them. And then I have another chart. The second one is things that I want you to already to know. So these are what ifs. So what if the person passed away owning property in multiple states? Okay. If you have a California trust because you're a California resident, you can register or vest or deed interest in all of the states into that trust. So if I buy a home in Tennessee and I close escrow, I can tell my escrow officer or the attorney if they're doing the closing to rename or put that property in my trust at the outset. So when they ask you and they're preparing the paperwork, how do you want to take title to this home, Jennifer? Jennifer is going to say, put it in the Sawday Family Trust. And I provide documents to them, a copy of the trust or the certification, and I give them instruction on how to put it in. So when the person is typing up the deed from the seller to the buyer, on the bottom, it's going to go straight into my trust. So if I own property in multiple states, we can do deed work in all the states. I can do some states I can't. And if I can't do it, then we talk to an attorney in that state to do it for you. I got hired last week to do a trust transfer deed for property in Huntington Beach, and the gentleman lived in Florida. So the Florida attorney emailed me, "Hey Jen, we need to put this Huntington Beach property into my client's trust." So I prepared the deed, pulled title, checked it. He signed it, sent it back to me, and I recorded it. And now that home in California is in his Florida trust. So it's easy. Your home, if it has a reverse mortgage, also should be in the trust. The reverse mortgage lender may want to give you permission, but I don't care. I want you to put it in. Most lenders now are getting better at it. It's not against the law to put it in the trust. If you put it in the trust and you pass away, that means the successor trustee can sell the home quickly without having to go through probate to pay off the reverse mortgage lender and then keep whatever equity is left. It's good to have it in a trust so that we can sell that property, pay the lender back, and move on. That's a good idea. Okay. What if the property is underwater? If the property is already in the trust and the person has died, then you're going to be doing a short sale. And you're going to work with the lender and you're going to have to figure it out. You may not get any money back. You may have to pay the difference. That situation is very unique. So we would have to talk about it and talk to the lender and figure out what would be best in that scenario. Okay. What if one sibling wants to keep the house and the other one wants to sell? Sometimes it depends on who the trustee is. If you have two people and one of them wants to buy the other one out, then they have to get it appraised, make an offer, and the trust essentially can sell it to the sibling that would like it. And then the trust would receive cash, and then the cash would go to the other sibling who wants to buy out. If there's a disagreement and we have multiple siblings and we can't work it out, we can go to court, we can go to mediation, or if the trustee just wants to dig their heels in, they might just be able to sell it and then deal with the fight later. So that needs to be worked out. Okay. So the next one, what if the person who passed away was in the middle of escrow? If the home was owned by the trust, we just need the death certificate and then we do a substitution of trustee. Easy. We can close escrow and move on. It does take a while to get the death certificate. There's going to be a small holdup, but it's not going to be fatal to that sale. Okay, so here's what I was talking about. You see the word in bracket, Hegstead. What if a trust was never funded? Sometimes we have a trust set up and then we have a schedule on the back that lists what the assets are. And let's say we pull title and now the house is not in the trust. We can see it. The person didn't record the deed or they didn't understand or they forgot. So I can go to court, probate court, under a trust petition to say, you know what, Your Honor, this person forgot or didn't know how, or for some reason this house is not in this trust. For me to do that, I must have evidence, a writing intent for the person who passed to put it in the trust. So that's why these schedules are important, that lists where all the properties are, because that shows the manifestation of intent of what was to go into the trust. So we do the Hegstead petition. So when we talk about Hegstead in LA County, we can get a hearing date quickly, about 3 to 4 months. In Orange County, my hearing dates are usually set 9 to 12 months out. So it may be quicker to go through a probate. Get the orders and letters right away. Sell the property in 60 days versus waiting 9 months. So we have to figure out pros and cons. Which one do we want to do? Do we want to do the Hegstead or do we want to run an open probate so we can sell the house? So we have to talk about it, figure it out, and get all the parties involved to figure it out. What if someone claims they were promised the house? That's the tough one. If that person's not a child or a person normally entitled, I would do nothing. I would just call the bluff and see if they made a demand. If they made a demand or sued you or wrote a letter, then we would backtrack. But promises are hard. If it's just a writing and blah, 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 we don't have proof, we just kind of wait. So when people pass away, if the home is in probate, we have to give notice. So we give notice. If no one objects, we go forward. When someone passes away and we have a trust, we also give notice again to all the people entitled to notice. They have 120 days from the notice is sent to them to file an objection or a protest. And if after that time it doesn't happen, then the statute has been blown and we just do whatever. So there's a reason why we do everything one step at a time. It's helpful. What if there's unknown creditors? Well, that's hard. Usually someone will write to you to say, hey, so-and-so died, mail something to the house, or if you're opening probate, we run the publication notice in the newspaper. And so they have to file a claim. You have to give notice to all known creditors that someone has died if you're the trustee or if you're the executor, and the bills have to be paid. If you don't know who they are and there's no record, no papers, no evidence, they have 1 year from date of death to file a claim. So sometimes I tell my clients that if you think there's a lot going on here, let's not distribute anything until that 1 year period has passed. Um, what if a beneficiary lives outside the US? That's tricky. Different foreign countries have a tax. We require that we have a social security number or a foreign EIN for them. And so that's where we bring in a tax person that has a background in international tax, and they can help us figure that out. And sometimes the beneficiaries in these countries, like in Japan and Germany, they take a tax, so they understand what needs to be done. So we have that in there too. So we kind of bring it all in. What if the trustee is not acting in the beneficiary's best interest? The beneficiary has the right to make a letter, right? A demand letter. I want an inventory, I want an accounting, or I think you're breaching my duty to the trust in terms of doing whatever. So if that happens, that's where we come in to talk to the trustee by making a writing. This is what we think is going on, please respond. If the response is not good enough or sufficient, then we can go to court and file a petition. So there's a lot of good what ifs. So these are good questions. But I do have questions on the next page. And this one I did not like. And you'll see what I mean. Okay. So there were questions that I felt that each agent should already know the answer to as part of getting ready to sell a property. So one question that was asked often is the property owned by an individual or a trust? Well, I don't know. How do you know, right? I want you to do your job. I want you to talk to your title reps. I want you to pull a preliminary title report. I want you to look and figure out by reading the last vesting deed on that property, who was it owned by? I get sometimes that the chain of title might be convoluted or might not be clear, but we should print out all the deeds, organize them in recording order, and get the program report or the first page of the title report, lay it out, and then figure it out. You have access to this information more than I do. So I don't want you calling me to say I'm going to list this property. I think the homeowner died. Is it owned by the trust? I want you to already know this. You have a team of people that are willing to help you. You have your title rep, you have escrow, you have your broker, right? Figure it out. I also want you to ask the question. Sometimes I get calls, people say, oh, I have to open probate. I want you to go back and say, well, has this person actually died? I did a consultation 2 weeks ago, which kind of got me pretty upset. I was in there talking to the woman, and she was telling me about how her dad had a home and she needed to get ready to sell it. So I said, okay, well, it sounds like we might have to go through probate because I had full title and I saw that the home was in Dad's name. And she goes, oh, no, 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 but my dad's not dead yet. And I went, oh, well, that's interesting. Why are we here? It's too soon. Maybe he should set up a trust, right, to avoid the probate process. So I do want you to ask if there's a property owner that has died. I would like you to get the death certificate and put it in the file. Escrow's going to want it, title's going to want it. It's a good thing to have. And then I want you to ask the next question, has probate been open? You should know. The agent doing the listing should say, oh gosh, I'm sorry to hear that your dad died. I'm sorry to hear that the property was just in his name. It looks like he did not set up a trust. Then I want you to say, did the person that is working with you, did they open probate? Do you have a case number? Do you have the orders from the court? Do you have the letters? Do you need to correct this no matter what? And then you can ask who the probate attorney is, or if they're in pro per to grab their papers. The title and escrow is going to need that as part of the closing. And then when you ask who has legal authority to sign the documents, I want to know if you know who your seller is, right? The seller may not be the person that you're talking to. The seller is going to be the person that is in the capacity of the person who was passed. Is it the executor, the administrator, or is it the trustee? Or is it going to be the agent under a power of attorney? So I need you to line this up. Who has the legal authority to sign these documents, and what is their title? So if I'm selling property that belongs to a dead person, Jennifer is not going to be the seller. I'm not going to be the signer. It's going to say Jennifer, comma, trustee of whatever trust, or Jennifer, comma, executor of the estate of. That's going to be who my selling party is. And then it's nice to know if there's multiple heirs of beneficiaries because we have to give notice. In a trust sale, they have to communicate that we're going to be selling property. And in a probate, they need written notice. And a time period has to pass where there's no objection. So we can find out if this is going to be a contested sale or an easy one. So most clients that are selling property tend to have a son. Is this property going to get contested? Am I going to hear things from family? Is someone going to be upset? We'd like to know that ahead of time. So that should be part of your meeting when you're scoping out, getting ready to list the property. How big is the family? How many siblings? Who are the beneficiaries? Do they know that I'm here? Do you know that we're going to put it on the market? But you kind of have to it's nice to have those conversations ahead of time. You should know if your seller is retained an attorney. Sometimes they have all the documents that you need. The EIN number for the trust, a copy of the trust, or if it's probate, I can give you the orders and letters. This one people ask me a lot in terms of the agents. Is there an existing mortgage? I don't know. I mean, I think you could figure that out by looking at title. I want you to look and see if there's a deed of trust being recorded. I want you to talk to the seller. What's coming in the mail every month? Is there a statement? Is there a reverse mortgage? This kind of information should be gathered as part of your intake. And then this question was on Laura's list was, has the title company been contacted? I mean, I don't think that's my job. I think that's your job. I want you to pull in the title rep that you like to work with. I want you to call them. I want you to open up a pre-ram and get going and tell them you're going to be listing this property. And read through the title report and clear all the open items. That's not my job. I don't know how. I don't have access to that. All I can do is pull some deeds and just hope for the best. But when property's going on the market, I want you to join in and give me the platform and tell me what's going on with the property. I can't answer all these questions because I don't know. And then when you ask me, are there family disputes? I mean, we have to go back to the client and say, do we think this is going to be disputed and go that way? So it's kind of interesting when we talk about questions the agent should already know the answer to. I want you to do your homework. You have a team of people that are ready to help you. So it's hard, right? So when you get approached to do a listing in the probate or trust space, and you're talking to someone, I want you to find out what their capacity is in terms of, are they been appointed by the court? Are they seeking appointment by the court? Is there a trust document? Or do they need a referral to an attorney to begin the work? So I always want you to pull title, figure it out, and then say, oh, it looks like if this person is deceased, they're on title, we need to do some title clearing. And then bring in your favorite attorney, me or anyone, and we can look at all the options, quote the fees, and then do the timeline and tell you what we expect. The timeline's interesting because sometimes probate can be faster to get properties sold. A heck that's cheaper, but it takes longer and it's hard. And you can't go in ex parte for emergency orders in probate because the homeowner's dead. The court doesn't feel sorry for you. There's a way to avoid this and to set up the trust in the first place. So it's kind of interesting how all of this stuff does or does not come together. So when we talk about a trust and someone has passed away, there's a little bit that needs to be done in terms of trust administration. So what we want is we want clients to follow everything by the book, do it the right way. So the probate code says that if you're the trustee, you're required to give notice to everyone that is named in the document. We want that notice to go out. We want the attorney to prepare it. We want a proof of service for that notice. So we want all of that to go out. And the purpose of the notice is to give notice to all of the people entitled to notice, the spouse, children, people named in the trust, and possible admitted heirs. And then they have 120 days from the day you mail the notice until that expiration period to file a contest. And if they don't contest the trust, then you're clear to follow the rules of the trust after. So notice is important. And then for real property, a real estate held in the trust, there's also a requirement within 150 days of someone passing away that you notify the assessor that we have a death of a property owner. So those forms need to be filled out. The property taxes are going to go up unless there's an exclusion. And right now there's only two types of exclusions available for a property tax reassessment exclusion. One is the property is going to a surviving spouse or a domestic partner. So that is going to be excluded from being reassessed. But the assessor doesn't know that. So we have to tell them on their form. So they have a form called Death of Real Property Owner. If you Google that in the county assessor, the form will pop up and it's required to send it in. Your attorney will do it for you, but we'd like to do it. So that's one type of exclusion. It's going to the surviving spouse. The other type is the Prop 19 parent to child reassessment exclusion, but that only works if it was the primary home of the parent and it becomes the primary home of the child. And all the forms for that application are filled in within 1 year of date of death. And if we don't follow the rules and get it in on time, the assessor will reassess that property. So that's tricky, right? So we want to get that done. And then when people pass away in properties in a trust or in a probate and we're selling real estate, we don't want to use social security numbers of the person that is representing the family, meaning yours, or the social security number of the person who has died. So we have to get a new EIN number. And then we have to prepare documents to give you so that you can open up bank accounts. When you go to open escrow and you close and you get a wire in, it has to come into the trust account and stay there so that you can do your work and pay the taxes and the bills. So that's a lot, but it's easy. It's easy to do in the office. It's $1,000 job. It doesn't take a lot of time. We just get it done quickly. Most clients that come back to see me for trust admin, maybe a little more than 1,000, but it's just saying it's not like the probate fees where you're tied up in court. Once I activate them to be trustee, I usually don't hear back from them because they don't need me. I've told them everything they need to do and they go off and do it. And they distribute the money and they're good. And people need help with that. They need to know that we need to do the notice. We need to record the affidavit of death of trustee against the property. We need to notify the assessor. We need to get a taxpayer EIN number and then help with trust banking. So its activation work is nice. And then we let them loose. I become available if there's a problem, but I don't watch it every step of the way because when people set up a trust, they need you to do it. But if we have a probate, that's different. You should talk to the attorney if we have an attorney that's handling the probate. Make sure we do a notice of proposed action to send it out. There's a 20-day clearance on that we like to do for ideal for mailing. Make sure we have the letters, we have the order, we have the inventory and appraisal in from the court, and that we're selling it at the right price. And then after we give notice, we can make sure that there's no objections, write the attorney letter saying it's okay, we can close escrow. And then have the client put it in an estate account. And the probate courts here in California require that if the sale proceeds go into an estate account, we have 250,000 in different banks because we want the account to be FDIC insured. So there's a lot of little rules here and there on how to do that. So when you're opening a new transaction and you're selling property, I want you to do a little bit of homework. Reach out to the attorney, talk to the client, let's figure out the expectation, how the sale is going to go. And then we do it. We want a trust. So when you're out there prospecting and you run title, you have a list of people that don't have a trust, you can tell them. It's four things, right? So the trust, the will, power of attorney, healthcare directive. Put everything in it and put it away. It was kind of nice to have it. So do you guys have questions or things you want me to repeat or go over one by one?
No questions that I'm seeing in the chat. Laura has to step out, but
Okay.
yeah, thank you so much, everyone, and thank you, Jenny. And I will be
Okay, that's kind of
circulating
what it
the.
is. I just kind of want to just keep educating, right? We keep talking, keep educating, and kind of interesting. Yeah.
Jennifer, thank you very much. Please keep talking, please. Everyone, remember Jen Sawday, TLD Law Group is available for your buyers and sellers and your clients and yourselves. So please keep that in mind. You are all members of RARM, so utilize the benefits. Thank you so much, everybody. Please stay on and listen to Jennifer.
Okay. Well, I appreciate having you. At the last seminar that I did, we had so many questions. Everybody was in the middle of something. But I'm happy to go back. With you know, probate is one of those things that we need to avoid. When I was 21, my mother died, and she was 46, and then my father died a couple years later, and he was 54. And my dad was so young when he died, I didn't know that he needed to set up a trust. I wasn't an attorney yet. So I wound up having to go through probate. So when he died back in 2001, we didn't really have email. We really didn't have instant messenger. We were still on AOL. So I had to go to the attorney's office every month and sit with him for the check-in. So the check-in was file the petition, get the letters, get the EIN, do the creditor claim, inventory the property. And so every month I sat with him, and he was an attorney in Wilmington, and I watched him and learned how it went. And a year later, after we sold the house, the money went in the estate account. My brother got half, I got half, and then off we went. And it went well. It wasn't a difficult process, but it was expensive, and it cost me 16,000 in attorney fees. And I spent a lot of time at the mercy of the courts trying to figure out what to do. We want people to avoid that. We want people to set up a trust. So people are afraid of me, right? They don't want to talk to me. They don't want to consult. They don't want to come in. They think I'm too expensive. So what we want is we want you, when you go out there, to say, you know what, setting up a trust is not that scary. It's good to do. It should not be that expensive. It's a lot cheaper than probate. And educate clients and connect them with the attorneys that you know to make sure that we can give their service out there, that estate planning is important. And dial it down is just those four things. Most people don't need more than that. So I think I'm kind of ready to end it if you guys don't have any other questions or anything else you want me to talk about.
One question just, or two
I have a
questions just
question
came
here.
in.
Okay. So it depends on, so this question here is what happens when a member of the family is left out of the trust. It depends on who is being left out. So if one of the parents have passed away or someone has given everything to the surviving spouse, no one's being left out. California law says you can set up a trust, give it all to your spouse. But if you have children and you're not providing for a child, and you did not name that child's committed, it's considered what we call an omitted child. And if they are an omitted child, they have the right to get information, contest the trust, and say, I should get a share. If the child is being named, and then there's a sentence saying the child's being disinherited, then you're done, unless you think that that was done by lack of capacity, fraud, undue influence, and things like that. If the documents say an equal share to all of my children, and I'm not providing for grandchildren, grandchildren are not someone that's supposed to take. It's supposed to go to the next level, right? To the surviving spouse, to the kids. So if a child has passed away and they update the estate plan to say my daughter has died, my son has died, I'm not providing for their issue, we don't have a disinherited or an omitted child problem where they have the right to contest the trust. So it really depends on what's going on in that instrument, who's alive, and what the family tree looks like. So it's hard. So if you think that someone's supposed to take and they're not named, but they would not normally take because they're too far removed, then there's no grounds for a contest. So if a brother says my sister died and she gave everything to her kids, but I was supposed to get this, you're not someone that's gonna take. So that's a hard one. So that's where we sit and figure it out. So here's another question. Do people have to use the same attorney to update a trust? The answer is no. We're like hairdressers. You can go to anyone. You don't like me, you take your book, go somewhere else. You want to stay with me, just make another appointment and we do an update. So there's the other questions about cost. So the cost for setting up a trust is on a couple of different factors. One is, are you single or are you married? If you're married, I'm doing twice the documents. Documents for the husband and the wife, or wife and wife, or husband and husband, whatever. I'm doing trust, two wills, two powers of attorney, and two pest directives. If you have one property, and I'm putting that into your trust, for a married couple, my normal fee is about $2,500. For a single person, it's about $1,800 to $2,000. If you have more property, each property incurs deed recording fees. I have to pull title. I have to double check the deed. I have to prepare. I have to record and pay the recording fee. So if a couple has additional properties, it's about $500 for each extra property. So in California, when you put your primary home into a trust, the recording fee is anywhere from $25 to $50. And I will absorb that fee as part of my quote when I quote you the flat fee. Additional properties for recording that are not your primary home, the fees that we wind up paying for the recording is about $250 because of the SB 2 for the homeward fund type of thing. So that's in there. So then we have to do extra deed work. So if someone comes to me and they have three properties and they're single, then they might pay $3,000. So 1,800 for the base, 500, 500. But I write it out and we quote and we figure it out. If the properties are not in California and they're in Vegas or in Arizona, then the clients may pay the cost of the recording. Most of my clients is one home, single, simple, or married, one home, very nice, all to the kids, and we just do it. So they pay the normal fees, 1,800 to 2,500. So that's kind of what estate planning is. So if you have a trust already, go home tonight and pull it out. Get your stickies, right? And put it together. And I want you to open your book, right? Open your trust. And I want you to put a sticky on the page that says trustee. When you pass away and the office of the trustee is vacant, I want you to read it. Is that who you want? If it is, good. If it's not, then you have to talk to someone and do an update. Then I want you to put the sticky on the next part where it says, when I pass away, my trust property shall be distributed to X, Y, and Z. I want you to read that. That's your disposition provisions. I want you to read it. Is this going where I want it to go? And if it's not, then you have to go back. And then the next thing I want you to do is when you have your own trust, I want you to make sure everything's in it. So if you have a trust, pull your property tax bill or look for the one that's going to come in October, right? So my home in Long Beach, it says it's owned by the Sawday Dam Trust. It says TR on the bill. So I know that my house is in the trust. So when I get the account from Schwab, it says it's in the trust. So these are things that you have to think about. You have to make sure everything's connected. So we have a question here. Do we do out-of-state clients? The answer to that is no. I'm only licensed in California. I can only do California resident estate planning. So just like a realtor can't sell property in a state that they're not licensed in, I'm only can handle California. I can put property in another state into my trust, but I can't help someone who doesn't live here. So it's a good question. Yeah. So if you have a trust, go home and look at it. Go home and find it, right? I had a client a couple years back and he made me laugh. His name was Jason. And we pulled title. He had a home in Hemet. And he said, Grandma had a trust. And I said, I know she did. I can see it. I can see the deed. I can see the name. I can see the date. I can even tell you who prepared it. And he goes, well, where is it? I go, I don't know. You tell me. And we were about getting ready to go to court to get the judge to recreate it because he just could not find Grandma's trust book. So he started cleaning out her bedroom, and then he opened up her nightgown drawer, and he was going to throw everything away and donate. And underneath all of her underpants, he found the book. So look, don't hide your stuff. Your estate planning needs to be located. Your grandson needs to find it. Putting it in the underpants drawer is not the place for it. Put it in the bookshelf in the den. Put your attorney card on the fridge. Make it easy. So that way, if something happens, we know. Kind of interesting. So, yeah. Anything else, or how are you feeling? Okay. I think we're doing pretty good, Allison. If you want to wrap it up, I think it's just close to 3.
Yeah, let's wrap it up. Thank you, Jenny. Thank you, everyone. Appreciate your questions, and I'll be circulating the recording shortly. Have a great day.
Okay, sounds good. Thank you. And then you're welcome to email me or call me, and we can figure out how we can help. But it was nice to talk to all of you. I'll see you guys later.
Bye-bye.